we'll be following. Ryan, thanks so much. On to Project Drive Sober now, where the issue of drunken driving in Wisconsin recently went all the way to the U.S. Supreme Court.
What began as a Sheboygan OWI arrest in 2013 turned into a lengthy legal battle. NBC 26's Matt Jarko explains what this now means for Wisconsin drivers.
We'll hear argument next in case 18-6210, Mitchell versus Wisconsin.
The question before the court: does Wisconsin law allow police to get a blood sample without a warrant when a suspected drunken driver is unconscious? It's an issue today, but started 6 years ago when Sheboygan police arrested this man, Gerald Mitchell, for a 7th offense OWI. The police report shows the arresting officer took Mitchell to a hospital to test his blood, but Mitchell passed out on the way. The officer felt Mitchell was too unstable to perform a breath test and later went completely limp. The officer read an official form required to take blood called the Informing the Accused form. Mitchell was still passed out and could not respond, thus could not provide any responses to questions. Without a warrant, the blood draw was taken and later came back with a result of .22, nearly 3 times the legal limit.
The question here concerned the interplay between the Fourth Amendment and our implied consent laws.
Assistant Attorney General Hannah Jers argued the case for the state of Wisconsin. She said a driver in Wisconsin agrees to blood and breath tests just by getting behind the wheel.
Our argument was that the implied consent laws create an exception under the Fourth Amendment to that warrant requirement.
The Fourth Amendment protects against reasonable search and seizure. It was a big part of Mitchell's defense team's argument.
The state advances a bold and novel proposition here, that it can excuse itself from the Fourth Amendment warrant requirement simply by enacting a statute saying that its citizens have consented to a search.
The defense said a conscious choice is the bare minimum for consent.
The state has perfectly adequate means other than a warrantless blood draw to vindicate its interest in catching and punishing drunk drivers.
Prosecutors argued an unconscious person is a medical emergency. Medical staff will want blood for treatment. There's often a car crash involved, and the primary blood evidence is disappearing.
All of that together led the court to say almost always police will have exigent circumstances.
It means almost always police will have some reason to get a blood draw from an unconscious driver without a warrant.
It's pretty well established, I think, uniformly, that driving on the roads is considered a privilege and not a right, to which certain conditions can attach.
Now for a 2-on-2 traffic stop.
I think the court's decision is a recognition of just how important it is that law enforcement be able to have the means to effectively combat drunk driving while also then attending to all of the other needs that are often created by the actions of the intoxicated driver.
The ruling in this case upholds Mitchell's 7th OWI. It also helps set a standard for all cases moving forward. If you're passed out behind the wheel, police can almost always take and test your blood. Matt Jarko, NBC 26.
And just to show you how divided this case was, the Supreme Court's ruling was 5-4.